welcome to our first panel of the day, Global Approaches to Movement Lawyering. When we started organising last year, we knew we wanted to bring some of the voices of international movement lawyering to our Australian audiences. And that's not just because we have so much to learn from the way concepts of movement lawyering have fermented overseas, but also because building the power of communities impacted by injustice, particularly First Nations peoples and people of colour, is a global project and a global imperative. Yesterday, our keynote speaker, Vince Warren, talked about the need for international solidarity. He said, solidarity not just with your own communities and the communities around you, but solidarity internationally is key. It was a potent reminder that the struggles for liberation are connected. And each one of our speakers in this session is directly working with liberation movements in different parts of the world, and we are thrilled to have them with us this morning. So I'll hand over to Sarah to introduce these three formidable women.
It's such an honour to introduce our three panellists, all of whom are real leaders in international movement lawyering and have really changed my thinking about international solidarity and the use of the law as a tool for liberation. Marbre Stahly-Butts is the Executive Director of Law for Black Lives, a movement lawyering organisation in the US that works closely with organisers and communities to advance and actualise radical policy. She currently serves on the leadership team of the Movement for Black Lives policy table and helped develop the Vision for Black Lives policy platform. Before law school, Marbre received her Masters in African Studies from Oxford University and worked in Zimbabwe organising communities impacted by violence, and then in South Africa teaching at Nelson Mandela's alma mater. Noura Erekat is a human rights attorney, Associate Professor of Africana Studies at Rutgers University, and Fellow at Harvard Divinity School. Noura is the author of Justice for Some, Law and the Question of Palestine, which has received multiple awards. She's the co-founding editor of Jadila, an editorial board member of the Journal of Palestine Studies. She's served as legal counsel for a congressional subcommittee in the US House of Representatives, as legal advocate for the Badil Resource Center for Palestinian Refugee and Residency Rights, and as national organizer of the US campaign to end the Israeli occupation. Noura has also produced video documentaries, including Gaza in Context and Black Palestinian Solidarity. Alejandra Anchieta is the founder and executive director of the Mexico City-based NGO ProDESC and leader of human rights movements for migrants, workers, and Indigenous communities of her native country. Since founding ProDESC in 2005, Alejandra and her dedicated team have run strategic campaigns aimed at protecting the economic, social, and cultural rights of Mexico's most marginalized people. Among her most notable accomplishments at ProDESC, she has achieved unprecedented results to establish accountability mechanisms for transnational corporations in Mexico. I'll jump right into the questions now. First one goes to Marbre. Marbre, you've talked about rejecting law-centric theories of change. How have you put that into practice in establishing Law for Black Lives? What organisational values and structure have you adopted to ensure a different approach?
Thank you for that question. And first of all, just thank you so much for all of the work and labor and love that went into this conference and for this incredible panel of folks. I feel very humbled to be part of the conversation, but just shout out to what y'all are organizing and how important it is to be planting those seeds. So thank you for your work. Yeah, so I like this question. I think I really always revel in the chance to talk about our theory of change, which is how we think change happens. I think this idea of rejecting the idea that it's through laws or through courtrooms or through wins in courtrooms that change happens is really important, because law school is so much about indoctrinating you into thinking that you are powerful because you have the tools and language of the law. And I think that for us at Law for Black Lives, for us as a movement in the United States who's trying to really overturn the oppression of people of color, of Black folks, of femmes, of queer folks, that really understanding how we believe change happens is important. So I want to just start by saying that, like, we reject a legal-centric theory of change, and what we believe is that it's through movements, through when folks who are directly impacted organize themselves and work to shift power, that change can and does happen. And so if you believe that. If you think change happens not because you win a case or lose a case or you pass a law or don't pass a law, but change happens when folks are inspired and sustained and supported in organizing themselves with allies and across borders and across issue areas, then your attention is related to building those movements. And the law becomes one of many, many tools in that toolbox to build movements, but not the only one and not the central one. And so for us at Law for Black Lives, our origins are really inside of movement. And so in 2015, as many folks know, it kind of precedent or the precursor to the massive uprisings last year was a series of uprisings across the country following the killing of Mike Brown in Ferguson, Missouri, and also here in New York, Eric Garner, of Sandra Bland, of really like countless Black and brown people who the police had killed, but also by this reality that in the United States, our communities, Black communities, are occupied by police, but neglected in almost every other way. So whether it's education, whether it's health, whether it's food, security, the Black neighborhoods are overinvested when it comes to policing and underinvested in when it comes to all other things. And so in response to that, there has been literally decades or centuries of riots and uprisings. But in 2015, there was an example of this. And Law for Black Lives comes out of that moment where lawyers and legal workers found themselves being asked to perform very specific tasks, to do jail support, to help find and post bail, to help research and navigate this system, to find as much accountability as possible, which is a very small amount, for police who were involved in misconduct, and to navigate and research what was possible in terms of the legal framework. And many of us were asked to do that, and we're doing it alone and in a silo. And so what was really clear to us is we had to kind of find a space and create a space where lawyers could actively follow movement and support movement in a way that was about building the power of movement and not about winning a case or building the power of law. And so Law for Black Lives comes out of that moment. We had in 2016 a massive convening and really asked organizers who were leading this movement of liberation what they needed from lawyers and from us. And they said, we need you to organize lawyers. Number one, organize lawyers away from gatekeeping, away from being folks who actually limit the ability of folks to obtain power by being gatekeepers. We need you to organize lawyers to radicalize where they think about the law, to open up space inside of the law, and organize lawyers to protect movement. The law is a mitigation tool. It enables us to speak the language of power, and in some ways to protect people from being houseless or being inside of a cage when it's used well and wielded well. And so help us mitigate some of those harms. And so I think there was a really clear call for us as movement lawyers to flank movement. And so everything about kind of our founding is founded in this moment of figuring out, and I think I'll also say, without throwing too much shade on anybody, that I think there was a reality that the traditional legal infrastructure in the US, at least, was not actually responding to radical movement, that it was so entrenched in its own existence in kind of the non-industrial complex, profit industrial complex, but also in real status quo, and the fact that as lawyers, we have a certain kind of power and access, that when radical young queer Black folks were demanding that the system actually be dismantled, that they found themselves often alone without the legal support they thought they had. And so it was really important to build an infrastructure that didn't respond to the legal field or the kind of legal moment, but instead responded to movement and defended and protected and took its lead from movement. And so it did things that felt impossible or felt unlikely, even if it was kind of against our legal training in some ways, that we followed the movement to do that. And I think, since then, our work the last 6 years or 5 years has been dictated by movement. And so number one, we take on the priorities of our partners who are all Black-based building organizations and Black networks across the United States. We take on the policy priorities, but also like our day-to-day work is dictated by what they need. And so that means that we are flexible and agile. And so we've built really an infrastructure that is small and that is tight, that is able to respond to the needs of movement in different ways. And I think our values really speak to that, to a commitment to following the leadership of folks who are directly impacted, and a commitment also to organize ourselves kind of out of a job. And so we do almost nothing with lawyers by ourselves. There isn't a coalition we're part of, there isn't an initiative that we're pushing, there isn't a project that we're engaged in which is just a bunch of lawyers in a room, that we are constantly in deep relationship with organizers and asking, what is the legal piece of this that we can hold, but also are there other ways that we can help you strategize around this? And when can we lean back and shut up and listen and figure out what is helpful and how we can build. And so for us, our relationships are really kind of dictate our values in many ways. And so we are in deep relationship and non-transactional relationship with movement actors across the country. And that for us is a really important kind of a way to follow the leadership of movement. And so that for us is how we kind of try to and continue to like adapt ourselves to movement and respond to the needs of movement. I was like, I should have said period.
No, I mean, I'm still processing it. That was just so amazing. And like to hear, I think, yeah, so many of those, I guess, struggles with the traditional legal models, but also sort of thinking about law as, you know, building power and non-transactional, yeah, is something we can really learn from here. Alejandra, you've also established your own movement lawyering organization in Mexico, ProDESC. Can you tell us about ProDESC methodology and particularly about comprehensive defense and how that works in practice?
I just wanted to second Marble, thanking all of you for this opportunity and for the amazing organization of the event and for maintaining the contact and also being flexible in this pandemic time is more important than ever, and you were on the point. So thank you so much for that, and thank you for giving me the pleasure to share this reflection with my colleagues. And I had the opportunity to meet Marble in a huge meeting of lawyers from different parts of the world in Marrakesh, and I was just amazed for her and her work. And then when I discovered Noura and all her work and her writing, I was just like, oh my God, I have so much to learn from these amazing women. So I will try to share my experience. And answering to your question, I started this human rights organization, which is ProDESC. It is the Project of Economic, Social, and Cultural Rights, which is a Mexican organization based in Mexico City, but we have national work. And we decided to create this organization principally because we had a reflection as a human rights lawyers that in 2005, 10 years passed already after the globalization of the economy for Mexico with the NAFTA agreement between Mexico, the United States, and Canada. And of course, the narrative was at that moment that this economic agreement will put Mexico in the big leagues, and everything, it will become better as in Canada and in the United States. But in 2005, we were able to see a big tendency of regression, principally regression for the rights that were already established, collective rights of indigenous communities, also farmers, and collective rights, of workers. So that was one part of the reflection. And the other part was that the violence against women at 2005 in Mexico was terrible. We had at that moment, and now we are facing this higher number of feminicide, which implicates that women are being killed in Mexico. At least 9 women every day are being killed in Mexico just for the fact that we are women. And that is just an example of the precarity of life that women have in Mexico, women and girls. So with this environment, I started the reflection related to what we need to do and what is the best way to address at the local level the effect that transnational corporation and the transnational capital were having in our country and in our daily lives. So as another country from the global south that the legal system is not best, and we have also a very corrupted legal system and in general a very corrupted government. For us, being a lawyer that was not only litigating with a very rigoristic approach, taking the law to do that, we needed also to develop other strategies that will make the case that we are trying to do an example of what is the systemic gap that we need to fill. So we develop not only the strategic litigation, but we also accompany the strategic litigation with organizing processes, with a strategic communication, with lobby and advocacy, with corporate research, principally because the cases that we are litigating. And also the other important part that is a little bit new, but is more important than ever, is that we are also integrating in our methodology the perspective of communitarian safe measures, principally because the violence that people from communities and collective of workers are facing when they decided to defend and demand their rights. The other element that is very important in our methodology is we are not litigating individual cases. We are litigating collective cases, principally because in the cases that we are defending, the violations against the land, territory, and natural resources of indigenous communities are provoked by the lack of protection of the Mexican government, but principally for the presence of transnational corporations. So the inequality and the imbalance of power between a transnational corporation, a government, and an indigenous community is huge. And in order to have a chance to make a shift of power, we needed to do a very strong litigation. But the other part of our methodology, which is the stronger part, is supporting the organizing process of communities that know very well what they want and that have already mechanisms of decision making and that help us as lawyers and human rights defenders to define what kind of defense they want to do. So the organizing process is what we are trying to do with that is supporting the community and the collective workers to understand the legal strategy, but also the social impact that this case is going to have for their lives and for the lives of their community, and probably for other communities in the country that are facing the same pattern of violations, because corporations are reproducing the same business model and the same pattern of violations in their communities in Mexico, but also in other communities, for example, in South Africa, in Honduras, in Guatemala, Salvador, probably also in Brazil. So what we are working very hard is to understand as human rights defenders that the legal approach is important, but it is not the center for achieving the success that we are trying to do, which is principally regaining power and building and supporting collective power of communities and collective of workers. So that is just a general approach of the integral defense methodology that we were able to build, and now we are also able to connect other communities, indigenous communities that wanted to develop the same methodology in their own countries, and we are also able to connect with other lawyers that are supporting social movements through a global network for lawyers across the world that Marble and I and other amazing women are also part, trying to reproduce this approach not as a recipe and not as a model, because I personally don't believe in models to replicate, but just as a hint or as a key to have a different approach of how to use law in a powerful way for making their collective power the real tool for changes.
Thank you so much. I think that on that theme of building power, which came across really powerfully from you and Marbre, really feeds into the question that I have for Noura. Noura, in your book, Justice for Some, you speak about law as politics and the way that international law can serve the cause of Palestinian liberation, but also the many flaws of international law. Could you speak to us about some of the ways that law can be used to advance Palestinian liberation and its many pitfalls?
Much. I want to echo the gratitude that my sistren have already expressed for the organizers and, especially for their witness and commitment. I also want to emphasize just how, it might be taken for granted for folks, but for Palestinian advocacy to even be included in a, rebellious law conference, that's a thing of late. That is also the manifestation of struggle and the insistence that our struggle is one for liberation and not an aberration. And so very much in line with that, the law, what I show in the book is kind of, to echo what Marbre was saying, was to illuminate the relationship between law and power. There is an assumption that international law, by virtue of being international law, somehow if we say you have to follow the law, that you're saying that there's something lofty, that there's something noble. And yet the very history of international law is a history of plunder, is a history of giving Spanish, conquerors the right to pillage and plunder, not under papal authority, but under the authority of the Enlightenment and what we know as natural law or jus gentium. It established Europe as the modal civilizational framework, republican framework by which every other society had to emulate. And so Palestine fits within this broad and long colonial and sordid history of the development of international law, which develops for the specific purpose of expanding empire, of how to regulate access to the sea and the transatlantic slave trade, of how to have access to these lands that belong to native peoples, not only in the African continent, but across the Asian continent. This was about facilitating expansion of empire. Now, how do we say all that and then say, well, then how is the law not the primary target of our advocacy? That has to do with our different approaches. My personal approach is to accept that international law, like other structures of domination from the economy to the military, are inevitable, are inescapable. That should we escape them, there should be a moment of revolt and revolution. We don't exist in that moment, though it's not an impossibility. So insofar as we exist in these conditions, right, perhaps that are leading us to that, how do we use the law then to advance our cause, notwithstanding all the risk that it imbues? And so, my thinking around it is that, the law is power, right? But unlike the realists who simply believe that might is right and use it, in the words of Marty Kuskiniemi, as an apology for power, right? It's that the law can be leveraged in the service of emancipatory struggles if wielded in the sophisticated service of political movement. This is a movement lawyering approach, that the law can oppress, the law can help advance a cause. The law on its own doesn't promise any of that. It only promises a battle. It only promises a contest. How the law is going to manifest itself is a reflection of what that balance of power looks like. And that balance of power isn't clearly given. Yes, for example, in the case of Palestinians, Israel is the only nuclear power in the Middle East. It is the 11th most significant military in the world. It is part of the OECD because of its economy. It is world's empire, self-proclaimed most unique ally, and yet Palestinians, right, have been able to wield the law in the service of emancipation, most brilliantly during the 1970s at the apex of Third World Revolt, when the non-aligned movement in the Third World mobilized in an outright armed struggle against colonial powers and imperialism for self-determination. And in that moment, Palestinians were able to overcome their juridical erasure, enshrined in the Balfour Declaration, reified in Security Council Resolution 242, were able to affirm the juridical status of Palestinians when they declared that the PLO is the sole and legitimate representative of the Palestinian people, thereby negating this eliminatory framework that Palestinians were mere Arab refugees that can be shuttled around to other places across the Middle East. They were also able in this moment to affirm that Zionism, like apartheid, like colonialism, right, like capitalism and imperialism, was a form of racism and racial discrimination that needed to be overcome in Resolution 3379. And then in 1977, together with this non-aligned movement, also enshrined that guerrillas are not criminal terrorists, but are in fact legitimate combatants with the right to fight, who can use violence legitimately and can kill, can be captured, can be exchanged in POW exchanges. I mean, this was all in the language of law, but none of it would have been possible without the political movements that were actually expanding the space for power, in which then the legal activists, the legal advocates were able to step in and translate it into the language of law. Not those conditions that exist are no longer forthcoming. And now the use of law, for example, on behalf of the Palestinian struggle is much more risky. And I show, and many others have shown, how it's precisely the law that's oppressing Palestinians, right? It was, so many people say Israel is building settlements against international law. And yet the truth is that Israel is able to expand its settlement enterprise because of occupation law. Because occupation law recognizes Israel's presence in occupied territories as legitimate for the sake of reverting, to a status quo ante, and yet they are using the ambiguity within the law to assert that the territory is not occupied, that it's disputed, and to use this fallacy, legal mythologies, right? But it works in law, legal mythologies about what is military necessity, about time, right? When Israel's Supreme Court justice of 20 years says that there is a distinction, right, to say why settlements are not illegal. And what he does is he makes a distinction between permanence. He says the settlements are not permanent, right? But they're also, what is the word that he uses? And now it's blanking because I obviously didn't write this down and it's going to come at the wrong moment. Not inevitable. Permanence versus, it'll come at the wrong moment. In any case, it's a temporal fiction about time. That it's something that doesn't necessarily have an end, but doesn't not have an end in order to justify the presence of settlements, right? And so similarly now, when we look at Gaza and the fact that Israel, and today, I just want to comment on this today, that the US as Israel's primary imperial patron funded Israel with another $1 billion for an Iron Dome system under the framework of Israel's self-defense in a way that turned all of Gaza into a boogeyman. It turned 2 million Palestinians into an absolute blob. Why? And here's something really important, and why I never lean into the law in order to articulate a language for freedom. That there is no way that the law can challenge a framework of racism and colonial domination. The way that you are able to say that Israel has a right to self-defense against a besieged population that is, living on subsistence for survival is only to be deferential to a racist framework. that all Palestinians are somehow monsters and that their life's work is to antagonize Jews and Israel in the best case scenario. It's absolutely racist. And so, but Israel has been using the language of law in order to continue its violence against Palestinians. Nobody has been prosecuted for the systematic wars against the Gaza Strip in 2008, 9, 2012, 2014, 2018 in the Gaza March of Return, 2021. And it's not because Israel got away with it, but it's because Israel actually used the humanitarian law and laws of armed conflict to shrink the category of civilian and to expand the category of combatant. So use the language of law. It's what I call the shrinking civilian. It's a legal technology that made more Palestinians subject for target and killing. This is the law that we now want to use on our behalf. Our conditions are not obtaining for Palestinians to use the law to advance our cause in very obvious ways. And I know that I'm going to get a chance to talk about how we can use it and what it can do. But here, just to caution us, that the only thing we have to advance our struggle is our political commitment and critical mass movements.
Thanks, Noura. That was just an amazing articulation of some of the principles that we really wanted to draw out in this conference. And I'm going to jump in for the next round of questions here. But I guess just following on from that, that theme of colonization and the law, how those two are intricately connected, how the law has justified and perpetuated colonization. I'm really keen to hear from you, Alejandra, particularly in your work around First Nations and Indigenous communities in Mexico. How do you address the power imbalances that there are between lawyers and those communities in this system of colonization?
Brooke, I think it's a very important question, and we had been struggling with the power dynamics, principally because in the human rights movement, lawyers have the tendency of present themselves as the saviors, no? The saviors of poor people, the saviors of oppressed people, and the ones who have the answers for the problems of these communities. And when we are not able to have a critic reflection about the law as a tool of oppression, and also a critical approach of how to use our privilege as trained lawyers, we repeat the same patterns of patronizing attitudes, telling people what they have to do instead listening people about what they want to do and what is the strategy for them and how we can accommodate their strategy, which is principally a political and an organizing strategy of resistance. We as lawyers have to listen in that strategy to accommodate it in a legal frame, no? And then we can litigate. But in most of the cases, human rights lawyers doesn't really have a political analysis of what it means to do this kind of work, and what are the privileges that we have. If we are coming from the city, if we are also a professional, we have a professional career, if we are speaking Spanish and we don't speak the indigenous language of that community that we are going to support, what does that mean for them that you are going to litigate their case in a language that they really doesn't acknowledge? All those dynamics. And if you are even in Mexico, the color of your skin gives you different kind of status. If you are lighter, than them, of if you are darker as them, if your hair is blonde, or if your hair is obscure as mine, if you are coming from a private school, or if you are coming from a public school. All these intersectionalities of power are very important to address a critical approach of working with indigenous communities and also with collectives of workers, because there is also the class the difference between lawyers and workers, no, and lawyers and communities. And if we don't have that reflection, and if we don't train us not only as lawyers but also as organizers and political activists, we are going to reproduce the same patterns of colonization in a way, and also patronizing communities when the strategy has to be different, no? And when, in order to also gain a very important element for the strategies and the cases that we are litigating, which is building trust with communities and building co-responsibility with the communities. If you don't have that self-reflection and that political approach of how to use the law and how to understand your privileges, the case is going to fall, principally because with the corruption, the violence, and the money that corporations are setting for dividing communities is just huge. So thinking in these power dynamics is more than ever needed and strategic, and you have to put time. You have to put also analysis. You have to develop a power analysis of the case, but also a map of power that you are going to develop with the community, with other organizations, with the international organizations of human rights, because if it's a huge case, you have to collaborate with organizations from the global north. And that also implicates power dynamics, because organizations in the global north, even when they are very solidarious with us, they have access to better funding, they have access to media in a different way, they have access to do this kind of work without the risk of being threat, kill, or disappear. That is something that lawyers from the global south, human rights lawyers from the global south, and the communities that you are working with, is a risk that we are facing every single day. No? So having a dialogue, identifying, making visible all these differences and how these differences are playing a power dynamic with our allies in the global north is also very important, principally because solidarity has to understand power dynamics and has to understand the privileges that organizations from the global north have, even when they are doing a very good job, and even when they are fighting the good fights. Their privileges are different, and they probably are not going to be killed, tortured, or disappear for litigate a case. And we are going to be. So the power analysis goes inside of your organization, goes also inside of you as a human rights lawyer, goes also when you are working with the community, but goes at the same time in working in a transnational level. No? So I don't believe that we are going to escape of these power dynamics. we are probably going to reproduce that. But at least if we are conscious of this, we can have a more open and transparent dialogue about it.
Very good. Thanks, Alejandra. I mean, these are such important themes for us, like ideas for us grappling with. And I guess just that theme of risk of privilege is concept of privilege is so important for us to understand. And I'm just really excited to ask Marbre as well to comment on this, not just understanding privilege, but actually as lawyers, what does it mean for us to risk our privilege, and why is that important for shifting powers to the communities that we want to support?
That's so hype. I'm like literally writing down quotes from both of y'all because there's just so much. It's so juicy and so good. So thank you again just for the walk and the brilliance. Yeah, so I feel really excited because I feel like often both in law school, and I don't know kind of how global the US law school experience is, but at least in my law school, the idea of power was almost never mentioned. Like we didn't talk about power at all. And so I think what Alejandra is saying about visibilizing power, both on like the meta, the global, the micro, the personal level, is so essential for us to begin to think about how we actually start to make radical change. And I'll say, I identify as a radical, and we often quote Ella Baker, which I'll do again, I'm sure, before this panel is over, but she's an incredible organizer, leader from the civil rights movement here in the US, often undersung, but sorry, my baby's going to bed, so if you hear screaming, that's what's happening. It's a bath time. But, you know, she often talks about radical as being grasping at the roots. And so when I think about my politics, I think about it as a politic that's trying to unroot, whether it's capitalism, whether it's anti-Blackness, whether it's homophobia, whether it's misogyny, whether it's colonialism, that I'm interested not just in seeing the symptoms being treated, but an actual derooting of the causes of those symptoms. And if we are interested in seeing a radical shift in our global economies, in our global equalities, a repair of past harms, a shift in power is absolutely necessary. And I think for me, lawyers have become, even lawyers who are from backgrounds where they don't have that much power. Many of us were drawn to law school. I decided to go to law school when I was 12 years old in a courtroom, watching someone be sentenced to jail and having no power. I mean, if I could just speak this language of power, if I could just understand what was going on, if I could just speak the same words, that I would have power to change outcomes of people I loved. And so many of us went to law school seeking power. And even if you come from powerlessness, I think as Alejandra got to, there are so many layers in which you begin to both accumulate privilege, but also you already have it, right? And so I think it's really essential that we do a deep assessment of where we are privileged and how our privilege interacts with different circumstances and different moments, and different movements, right? The movements are also privileged in different ways. And if we are looking for liberation, that will require deep solidarity, which requires an acknowledgement of vulnerability, an exposing, an articulation of your power relationships. But I think law school specifically, and the law, and this goes to something that Noah said, is in the constant act of normalizing power inequalities and legitimizing them. And so I think I was really struck by this idea of the law is almost kind of a self-fulfilling mythology of legitimacy. And even as it shapeshifts, even as it changes kind of what is and isn't legal, it constantly is telling us that legality equals justice, or legality equals an appropriate use or legitimate use of power. And that is a lie, right? The law has so often and was created, as Noah said, and yielded as a way to maintain the interests of the rich, of the powerful, of often the white, of often the male, right? And that changes, but like that has always been the functioning use of the law. And so every single case we read is really an articulation, a manifestation of power, whether it is, and we define power, I think it's important to say too, of like the ability to control outcomes, right? And when you think about how many people across the globe don't have any ability to control the outcomes of their life, whether that is the land in which they are displaced from, whether or not the state kills them or doesn't kill them, whether or not here in the US, for instance, if you can cross a border or forced to go back to a place where you have no food and no water and no home, whether it is a woman's choice to decide whether or not she has a child. There are so many ways in which the law makes decisions that really like rob people of their power. And so I think it's really important that we as lawyers think about, because I think so often the cases we read and the things we work on become very obtuse, and power becomes this like phrase we throw around, but it really is about self-determination, your ability to actually control the outcomes of your life. And so often when folks reach the status of lawyer, they have so much personal power and political power. And I think it's really important that we recognize that whether if you have clients or you do movement lawyering, you do policy, the decisions you're making, the conversations you're having have an incredibly drastic impact on people's ability to keep their children, to keep their homes, to keep their lives, to keep their freedom. And that power that we begin to exercise in people's lives, I think often goes unseen in so many ways. And so I think this normalization of talking about it is really important. I'll also say, I think the necessity of shifting power is also a really important thing to think about. And this is another Ella Baker quote, but she often says that the reason why it's so important that not lawyers or politicians or people with money decide outcomes, but actually folks who are impacted is for three reasons. And this goes back, I think to Noah's point about kind of the political commitments and the power of movement, that it's essential that movements dictate and have the power to dictate their own outcomes. And she says one is because it's ethically right. The people who are most impacted should be able to decide what happens to them. That they should be able to decide what happens to their bodies, to their lands, and to their families. But it's also practical that folks who are closest to the problem are also closest to the solution. And that it's essential, if we want to get the right solutions, that we allow those folks who are actually in the heart of it, who actually have to survive the systems that we are building, that we are advocating inside of, that they are the closest to understanding the outcomes of the system and therefore must be the closest to determining the solutions for the problems we face. And that lastly, it's sustainable, that movements make things that are impossible possible, right? That things are only sustainable when social movements back them up and are behind them. And so I think it's really important when we say that we are lawyering on behalf of movement, that we are in deep relationship and kind of remove ourselves from the decision making around what are the outcomes or the solutions. And that's about being in a relationship. And I think Alejandra said this, that it's only through deep and non-transactional relationships that we are able to build and contribute in a way that isn't about us trying to use or abuse our power. That really is about collective power. And I believe deeply, we often talk about being on assignment, that there's this idea that if you are part of a movement, not because you're a lawyer, because that is who you are, and you obtain legal skills because you see a gap and use that as a way of supporting movement. If you are on assignment, that means you are accountable to somebody. And I think the real antidote to power is accountability. That the ways in which we yield privilege is really checked and mitigated by who it is we're in relationship with and who we're accountable to. And accountability is not something that accountability isn't justice. It's not the same as being able to be prosecuted by a court of law. It's about who it is that you have to explain yourself to, who do you have to go home to, who do you have to tell when you make a mistake to, who do you have to apologize to, who do you have to explain your actions to. And that is about relationships and home and community. And so I really do think, as lawyers and legal workers, as we really accumulate and navigate through different levels of power, we number one, recognize it, that we're in a constant, as Alejandra said, assessment of where we are positioned, right? And so, I may be a Black woman in the United States, in the belly of a beast, that gives me a certain level of power and privilege. And so I think, should be in constant relationship around what our power is. And reminding ourselves that so much of how we exercise power really goes unseen. And that's not an accident. The reason why I think the power is invisibilized is because it's very violent, right? And so it's much easier not to see the violence of the power that we are part of. And even, I think about it kind of even as I did public defense for a summer when I was in law school. And I remember constantly thinking about the ways in which we necessitate invisibilizing the ways that this system causes harm, because it really is very hard for each of us to live with the ways that we're complicit inside of that harm. And so I think it's really important that we visualize power, that we name who has it and why, and then we remember that if all work is to actually transform the society we live in, then ultimately we're trying to work ourselves out of a job. And so for me, my version of liberation, my version of Black folks and brown folks and women and queer folks being free does not actually involve courts. It doesn't involve lawyers. It doesn't involve people who go to school and accumulate lots of debt to then be able to speak a language that nobody else understands. Right? That's not part of my vision of what freedom looks like. And so I understand myself as using a tool that is meant to die out with oppression. And so I think clearly the society that I want to occupy has rules, it has accountability, but it doesn't have coercive courts that threaten death and threaten, cages and torture to get that accountability. And so I think it's important to remember that and to use your tool, to use it when you are asked to use it, and to be accountable to people as you use it. And so I think this piece around relationships is so important. And, you know, I often, when I was in law school, I had a professor who said you have to have a board of advisors, and it can't be other law students, it can't be other people who you're meeting in this space and who are gonna be like big deals in 20 years. It has to be people from where you're from or where you want to be. And so who are the people from your hood, from your neighborhood? Who are the people who you actually are fighting on behalf of, who can check you, who can be like, is this the right choice should I go to this law firm? Should I do this job? Should I be arrested at this protest? Those are questions that somebody in your community should be able to answer with you. So I think this idea of being in relationship is just such an important part of accountable legal practices and movement lawyering. And I'll stop there.
Thanks, Marbre. Amazing. I mean, I love so many of the ideas in that, and we are sort of running a little bit tight on time, so we're going to go. I just want to ask Noura one question, and then we might try and squeeze in at least one question from the audience. But I guess this notion of the invisibility of power in the way we operate as lawyers, and I think the common themes from both what you said, Alejandra, and Marbre, is really as lawyers having to have a conscious framework around identifying power. And so I was really wanting to ask you, Noura, in the context of your work with Palestinian activists, what's the importance of adopting a political framework to guide that work?
Yeah, everything. I want to also just say right now, I was struck by this idea, Alejandra, of you pointing out, right, the risks that Global South lawyers take every day, that Northern Globe lawyer or the Global North lawyers are only going to get clout for, right? And what that means and how that should help us navigate what opportunities we take and who we lift up, and what languages we use, right? And Marbre too, this, you know, your first emphasis on self-determination of the person, right? It's actually quite revolutionary to think about it that way, because so often self-determination is collapsed with the framework of sovereignty and statehood. And yet here you are taking it to this very visceral corporal place. It's also in our, what does it mean for us to be able to lead our lives forward, which creates a lot of complexity, because oftentimes the harms that we face are not merely external, but also within our own communities, oftentimes our own families, right? And you know, especially Alejandra, when you start out and tell us about how many women are killed every week and how easily, that's evidence of it, right? That we should, to maintain that complexity. And I think that the self-determination of the self helps lead us there. Also, I remembered the word as promised. It was permanent versus indefinite. Mahir Shamgar said that the settlement enterprise was indefinite, which means that it doesn't, we don't know what the end is, but it can have an end, as opposed to permanency, which doesn't have an end. Right? That's it. It's resolute. It was that legal fiction in time that he created. As to the question, what does it mean for Palestinians in organizing? Let me start by saying this, especially because we're talking about power and what it means to be in relation and of the self. So often when I throw down, right, I get people either mad at me or proud of me, right? But both camps will attribute either what they're angry about or what they're proud about to the fact that I'm a lawyer. That I speak so well, and it must be because I'm a lawyer. And I always have to remind folks, that's not true. I'm an organizer who became a lawyer. I learned how to speak as an organizer. I learned how to identify power as an organizer. I learned that power was diffuse and not merely comprised and located within the state and its military forms in organizing. I learned how to communicate to different audiences as an organizer. I became a lawyer after that. And yet the perception is that there's some magical thing about lawyers that makes them witty or fast on their feet. And it really does obscure the fact that the best theorists, the best thinkers, the wittiest, the smartest, the fastest are our organizers on the ground, right? And so there is no movement forward for Palestinians. There is no legal advocacy forward for Palestinians without an actual political movement. I'll bring it really close to home. This summer, we witnessed the unity of Intifada, or May, wasn't, we witnessed the Intifada of unity, which was the most significant in recent Palestinian history. It really culminated and worked around the removal, forced removal, ethnic cleansing, not the eviction or the displacement or the real estate dispute of 8 Palestinian families in Sheikh Jarrah in the Jerusalem neighborhood. It was their organizing. It was their organizing. The Israeli court had already ruled against them. The Israeli court in 1982 had already recognized that based on fraudulent papers that had been created both through a really dishonest lawyer for the Palestinian families as well as for the settlement organizations, that these lands belonged to the Israeli settlers, right? So it was a fait accompli. All they had to do was remove them. But it was Palestinian organizing. It was uprising that not only shifted the terms of that outcome, but delayed even the question of when the case would be heard. Because now the court knew that what it did was not going to be contained to the courtroom, but actually would be adjudicated in this broader field. Now, after all of this, the court still issued a decision where it granted the Palestinian families the right of occupancy, but not the right of title. And I think it's really important that we are all sitting on occupied territories from, Australia to North America and beyond, right? That was the same logic in Johnson versus McIntosh, where the U.S. Supreme Court in 1823 found that the Pinkashaw Nation didn't have the right to title, but only had the right to occupancy, and established what we know as a fundamental principle in U.S. property law as the doctrine of discovery. That only the colonial powers who discovered the land can possibly have title, just negating that indigenous peoples can even exist, right? And be contenders here. So, the idea that this is across time and still existing, but also unites us in these disparate geographies, but also, in resistance against colonialism, against settler colonialism. Where are we now in terms of Palestinians and political movement? The reason that we have any chance of winning cases in court has to also reflects the robustness of the political movement. And right now it's contested. We took a lot of ground recently, a tremendous amount of ground. We shifted the terms of the discussion, right? But we also know that the opposition overshot in order to take back, before we were able to consolidate those takings, to take back much of what we were able to achieve. And so we were reverting to this language of Israeli self-defense as a carte blanche for violence. So I think personally, one of the biggest cases we have right now, the most successful cases Palestinians have right now are basically in the form of defense work against the accusations of anti-Semitism, against the accusations that BDS is criminal, right? It's the defense litigation that I think we must continue. Our offensive strategies are up in the air. And I think that reflects complexity even within the Palestinian legal community, because so many Palestinians, many generations, fought for a long time to just get standing at the ICC. The fact that we're now there, right? It's hard for these very same, pioneers, Palestinian pioneers in the work, to now look at the ICC and say, this is a political body. This is not a legal body. They're not going to decide this case based on the papers that we submit. They're going to decide this case based on what's the prosecutor's next move? Where does Kamal Khan want to work next, right? What are the threats by the United States and Israel? It's a lose-lose situation for the ICC. If they prosecute Israel as we've been demanding, they're going to lose the United States and Israel and possibly other countries, right, in forms of defamation. If they don't prosecute Israel, they're going to lose all the global South countries that already think the ICC is a sham, like several African states who have actually rescinded from the Rome Statute. So this puts, it puts the ICC in this place. The decisions it's going to make, I think, are not going to be decisions on legal questions. They're going to be deciding how do we appease all peoples and emerge whole, right? Which is why the former prosecutor who recently stepped down, in my opinion, found, decided that Palestine was a state, but still deferred to an expanded panel to decide whether or not that meant that there was jurisdiction for the ICC to hear the court, right? She did the same thing. She was making all sides happy. And so here's that thinking of where are we politically in order to bring this case forward? I have strong opinions about this. My colleague and I, John Reynolds, have published an article basically that Palestinians should just go for the whole thing, right? Just go after the whole thing and say the whole thing is a sham. It's all apartheid, right? It'll be an indictment of criminal law as well, very similar to what radical Black activists did when they submitted the 1951 petition to the United Nations charging the United States with genocide, right? You might not win that legal case, but you're about to open up a lot of Pandora's boxes that could possibly mobilize more politically.
That was just so incredible. I feel like that was such an amazing note to end. I would probably not going to have time for any audience Q&A, but that was just, I think, to hear all of you speak about, the politics of the law and the way that the law can build power, but that it's, this real can also just be such a tool of oppression. It was just, so powerful to think of all of that. And I feel very lucky to have heard that myself. And I know that there's lots of people sort of posting comments as well, and, sharing their thoughts and just saying that, they're really inspired by this discussion.